Okay. Um, we have quite a bit to cover, so I'm just going to get started while people keep trickling in. But I just wanted to welcome everyone to the August installment of our Lunch and Learn series. Thank you so much for taking the time to join us on your lunch hour. Today's topic is Mahmoud versus Taylor and what it means for opting out of instructional material. I'm Kate Hamilton, and I'm the paralegal on staff in the Legal Services Department here at CSBA. I'd like to introduce our fabulous team of attorneys who will be presenting today. First, we have Bob Turk, our Chief Legal Counsel, and Senior Legal Services Attorneys Alex Worthy and Mariella Martinez. So before we get started, let's take just a minute to go over housekeeping. First, I want to let you know that this session is being recorded and will be available for viewing in the Legal Resource Library on our website. If you have any issues accessing the recording, please feel free to reach out to us. We're always happy to help you get access. It might take a couple of days to get it on the library, and I'll send out a notice saying that it's available. We, of course, welcome any and all questions. However, we ask that you mute yourself when you're not speaking, just for technical reasons, of course. Please feel free to put your questions in the chat or use the hand raise feature, whichever you prefer. There will also be a Q&A session at the end of the presentation, so you can always ask questions then. And one last housekeeping item, I will be sending out a happiness survey after today's program. It literally only takes 1 minute to do, so please submit that when you get a chance. We do value your feedback. Okay, let's get going on the agenda today. So today we are going to be covering, get us to the agenda. First, Mariella is going to go over the FAIR Act and then the California Healthy Youth Act. Alex will be going over Mahmoud v. Taylor, and then Bob is going to follow that up with policy considerations. So with that, I'm going to turn it over to Mariella to get us started.
Great. Thank you, Gade. And thank you all, as always, for sharing your lunch hour with us today to discuss this very important topic that you've been hearing about, I'm sure, for the last couple of months. We always look forward to our Lunch and Learn event and are happy you could join us. And I do see among the many of you that are joining us today, many familiar names and faces. So welcome back to you. And for those of you who are joining us for the first time, welcome. And we hope that you'll be able to join us again in the future and enjoy what we have to offer today and gain a lot of information from it. So, okay, as Gade said, I'm going to be discussing the FAIR Act as well as the Healthy Youth Act, both of which are California laws. Before I get into that, though, I want to provide a very brief summary of the recent U.S. Supreme Court ruling in Mahmoud. Alex is going to dive into that in just a few minutes, but I do want to provide, like I said, a very brief summary in order to provide some context here. So the U.S. Supreme Court case arises from a challenge by elementary school students of a school board's introduction of LGBTQ plus inclusive storybooks. But as we will learn throughout the hour today, that ruling has the potential to have a much, much broader set of implications. And again, we're going to get into that later today, and you will have the opportunity to ask us questions at the end or as we go along, as Gade said. So the fundamental holding in Mahmoud is based on the First Amendment's free exercise clause, which I'm sure you're all familiar with to some extent or the other. So relying on that clause, the U.S. Supreme Court ruled that where a school or its board adopts policies or curricular materials that the school has reason to know will, and I'm quoting here, substantially interfere with the religious development of parents' children and or will pose, again a quote, very real threat of undermining the religious beliefs and practices that parents wish to instill in their children, then the school has to provide notice to the parents of the policy or the material, as well as an opportunity for the parents to opt out their children of the policy or exposure to that material. So we've got two points here to note. One is notice, the other is an opportunity to opt out. So keep that in mind as we progress. So in addition to setting new legal precedent, this case has significant policy implications, as I alluded to before, and Bob is going to discuss those towards the end of our presentation, so hang tight for that. All right, so let's now turn to the FAIR Act and the Healthy Youth Act, which are the main topics that I will be discussing today. I want to bring to your attention an August 6, 2025 guidance regarding Mahmoud by the California Department of Education. Again, issued on August 6 of 2025, so just a couple of weeks ago. Before getting into the guidance itself, though, I want to make something clear, and that is that guidance is non-binding. What does that mean? It means that it does not carry the force of law, but it does carry some weight, and it helps us understand in this case, and in all cases, really, the CDE's position with respect to a particular issue. So at any rate, in the guidance that I have referred to, the CDE stated that the CDE, as well as California law, would continue to promote a safe, fair, and welcoming learning environment in all schools. So the guidance also went on to say that it is important to note that the new case does not invalidate or preempt California's strong protections for LGBTQ plus youth, protections from discrimination, harassment, and bullying. So state laws that contain these strong protections, they include the FAIR Act and the Healthy Youth Act. So let's turn first to the FAIR Act. So the FAIR Act is actually short for, as it states on the slide, for Fair, Accurate, Inclusive, and Respectful Education Act. And it provides that instructions in social sciences have to include the study of the role and contributions of certain groups of Americans, and that includes LGBTQ plus Americans, contributions to the economic, political, and social development of California and the U.S. as a whole, and a particular emphasis on portraying the role of these groups in contemporary society. Excuse me. I want to mention in this context Senate Bill 48, which was enacted in 2011, and it went into effect January 1st, 2012. So it's not a super recent bill, of course, but I do want to mention that it specifically added certain groups to this list that I just mentioned, and that included LGBTQ plus Americans. Again, LGBTQ plus Americans were not on the list prior to SB 48 becoming law. So SB 48 is important because it also important in other regards as well, because it also added some more requirements with regard to instructional materials. So for instance, Ed Code section 51501, it outlines prohibitions on material included in textbooks or other instructional materials. And what kind of prohibitions are those? Well, the section already included prohibitions of matters, and I'm quoting again here, reflecting adversely upon persons because of their race, sex, color, creed, handicap, national origin, or ancestry. But SB 48 in this context, in the context of Ed Code section 51501, added sexual orientation to the list. Moving on to the FAIR Act, or continuing with the FAIR Act, rather, it also provides that, again, quoting, and I'm quoting a lot of language here because it is important to take a look and consider exactly what the words are. But at any rate, the FAIR Act also provides that, quote, a teacher shall not give instruction and a school district shall not sponsor any activity that promotes a discriminatory bias on the basis of race or ethnicity, gender, religion, disability, nationality, or sexual orientation, or because of a characteristic listed in Ed Code Section 220. Well, if we look at Section 220, it states that no person shall be subjected to discrimination on the basis of several categories. And those categories include gender, gender identity, gender expression, and sexual orientation. So by mention of 220, Section 220, we expand the protections here. All right, if we can move on to the Healthy Youth Act. Gabe, can we move the slide? Perfect. Thank you so much. All right. So the Healthy Youth Act promotes the knowledge and skills that pupils need to develop healthy attitudes concerning adolescent growth and development, body image, gender, sexual orientation, relationships, marriage, and family. The purpose, as it states on the slide here, is to provide every student with the knowledge and the skills that they might need to protect their sexual and reproductive health from unintended pregnancy, HIV, and STIs. So, pursuant to this act, the Healthy Youth Act, instruction and materials cannot reflect or promote bias against any person on the basis of any of the categories protected by Section 220, which, of course, I've already noted, includes gender, gender identity, gender expression, and sexual orientation. Okay. In addition, instruction and materials have to affirmatively recognize that people have different sexual orientations. And when discussing or providing examples of relationships and couples, the materials have to be inclusive of same-sex relationships. Finally, instruction and materials shall teach pupils about gender, gender expression, gender identity, and explore the harm of negative gender stereotypes. So I want to go back to that CDE guidance that I mentioned before. And it's important to note that it states in no uncertain terms that Mahmoud should not be interpreted to require or allow the erasure of any particular group from public school curricular content, and that California state law continues to prohibit discrimination against any particular group in curriculum or instruction. So I do want to mention, lest we think that this concept of notice and the ability to opt out is something completely new to the legal scene, I do want to mention that under California law, districts and county offices are required to provide notice and the ability to opt out of certain instructional content, but only in very limited circumstances. And this court case appears to significantly expand the type of instructional content for which notice and the ability to opt out is required. So let me give you an example. Education Code Sections 51938 and 51939, they are part of the Healthy Youth Act, and they require that districts and COEs provide parents or guardians with notice of planned instruction in comprehensive sexual health education and HIV prevention education, and that parents also be provided the opportunity to opt their students out of such instruction. And as an interesting side note, the CDE, as a matter of fact, has published a sample notification and opt-out letter for this purpose. Also, something important to mention is that per the Healthy Youth Act itself, the opt-out provision that is contained in that act does not apply to instruction or materials outside the context of comprehensive sexual health education, including those that may reference gender, gender identity, sexual orientation, discrimination, bullying, relationships, or family. So it will be very interesting to see how the ruling in Mahmoud and these California laws end up playing together before the courts. I'm sure we'll see quite a few cases that creep up here and there, in which we will be able to see how other courts, lower courts, engage Mahmoud and the California laws that I have just gone into. So I do, in closing, want to state that if you take one thing away from this webinar, it is that if you encounter a Mahmoud issue, notice, opt out, you should immediately reach out to us, to legal services, or other legal counsel for advice and guidance. This is not something that you want to take lightly. This is something that will require legal help. So with that, I'm going to turn it over to Alex for a deeper discussion of the ruling. Alex?
Perfect. Thanks, Mariella. Okay, so Mariella covered some California-specific laws, and now I'm going to turn over specifically to the Mahmoud versus Taylor case, which is a Supreme Court decision, so United States Supreme Court decision. It was based in Maryland, but because it went up through the Supreme Court, it is the federal law of the land, which means even though it started in Maryland, it does implicate California school districts. Okay, so I've got two slides on the Mahmoud versus Taylor case. The first slide is going to really just be talking about the facts of the case, and I will talk about why it's important that we go into those facts. And then the second slide is going to be more of like the legal analysis. And then Bob is going to finish out the webinar talking about policy implications from this case. Okay, so the Mahmoud case, as Mariella mentioned, it is a big deal. It substantially changes the landscape regarding parent rights to opt out their children from instructional material. So this case came down June 27th of this year. So it's a very recent case. And this is really the first school year that we are having to implement policies based on this case. It sets new legal precedent and has significant policy implications. As Mariella also mentioned, this is a First Amendment case that really considers the impact of personal religious beliefs in the context of the public school system. Okay, so as I mentioned, this is a case from Maryland. And again, because it's a Supreme Court case, it applies to us in California as well. This case kind of came about because in the 2022-2023 school year, the board of the Montgomery County Public School System began using LGBTQ storybooks in elementary school systems. The books were used in the context of teaching literacy, so for reading skills, reading comprehension, but they were not being used to teach about gender or sexual orientation, but they were just in the mix of books being used for literacy. Shortly after these books were introduced, teachers and principals started receiving an influx of requests from parents to have their children opted out from reading of those books. So the parents wanted their kids to be excused from using these books in the classrooms. The parents in those cases claimed that the use of the LGBTQ storybooks were, quote, pushing the ideas of gender ideology on their kids. So that was the claim from those parents. And initially, the board compromised with those objecting parents and allowed them to opt out of the instruction of those LGBTQ books, which the court actually noted was consistent with the board's policy for guidelines for respecting religious diversity. So initially, the board allowed for opt-outs. However, in March of 2023, the board actually changed course. They specifically said that they started receiving so many requests for opt-outs from the LGBTQ storybooks that it started causing a significant disruption in the classroom. And the board also noted that when children were excused from these textbooks or from these storybooks, the children were prone to stigma and isolation from their peers. So that's kind of what the board cited when they decided to reverse course and no longer allow the opt-outs. So from at that point, a group of parents and parent right organizations grouped together and they decided to contest the board's no opt-out policy, claiming that it infringed on their right for free exercise of their religion. And again, this started in Maryland, so it went up the Maryland court system, and the lower courts actually sided with the school board. And then the appeal went all the way to the Supreme Court, and the Supreme Court has now reversed those decisions. If you could advance to the next slide, please, Gabe. Okay, so the legal analysis of this case. Really, the Supreme Court here was addressing the question of whether parents had the right to receive notice and the right to opt out from instructional material that substantially interfered with the religious development of their children, or posed a very real threat of undermining the religious beliefs and practices that the parents wish to instill in their children. So the case, again, the facts of this case were based on LGBTQ storybooks, but the question that the court answered is kind of broader. Again, it's instructional material that substantially interferes with the religious development of their children or poses a very real threat of undermining the religious beliefs and practices the parents wish to instill in their children. So in the analysis, the Supreme Court actually relied on a previous Supreme Court decision of Wisconsin versus Yoder. And in that case, there was an Amish family who wished to withdraw their children from conventional schooling after the 8th grade. But that request was actually in direct conflict with a Wisconsin state law that required children to attend school until the age of 16. So in that Supreme Court case, the court held that parents had the right to direct the religious upbringing of their children, and that Wisconsin's compulsory attendance laws placed a substantial burden on the religious practices of the Yoder family. So ultimately, the Supreme Court in that case sided with the family, saying that they had the religious right to direct the religious upbringing of their children, and requiring them to attend school after 8th grade interfered with that right. So again, the Mahmoud versus Taylor Supreme Court decision relied heavily on the Wisconsin versus Yoder case. So for that reason. And again, the Mahmoud case is a First Amendment case dealing with free exercise clause, which, as we probably know, prohibits the government from restricting one's right to practice their religion. And in the Mahmoud case, the Supreme Court said, this is a quote, "At its heart, the free exercise clause protects the ability of those who hold religious beliefs of all kinds to live out their faiths in daily life through the performance of religious acts, and that the practice of educating one's children in one's religious beliefs receives a generous measure of protection from our Constitution." So they said that this is a right that parents have to direct the religious upbringing of their kids, and that right is not just within one's home, but it extends outside of their homes as well, and in this case includes the context of schooling. So ultimately, the Supreme Court in the Mahmoud versus Taylor case held that parents have the right to receive notice and have the ability to opt out from instructional material that substantially interferes with the religious development of a child or poses a very real threat of undermining the religious belief and practices that parents wish to instill in their children. The Supreme Court, importantly, did state that this analysis is always going to be fact intensive, which means you need to look at each opt-out request individually to make the analysis of those facts before you can really move forward and excuse a child from specific instruction. With that said, though, and I'm sure Bob's going to cover it in his portion of the policy implications, school districts do not have the ability to say, an individual's personally held religious beliefs are not substantial enough or are not significant enough to allow an opt-out. So there is a caveat there. Every analysis needs to be fact intensive. However, school districts do have to be wary of other people's religious beliefs, and whether or not those are sincerely held is not for the school district to decide. Okay, so again, coming back to the holding in Mahmoud, the Supreme Court wrote that these LGBTQ storybooks impose upon children a set of values and beliefs that are, quote, hostile to the parents' religious beliefs and exert upon children a psychological pressure to conform to their specific viewpoints. And the Supreme Court said that this is contrary to the First Amendment. The Supreme Court also did mention that removing children from public schools in favor of maybe private schooling or homeschooling is not an appropriate answer here. So that was something that had come up in the oral arguments from the case as well. So interestingly and importantly, which really kind of leads to Bob's discussion on policy here, is that the Supreme Court said parents have the right to receive notice and have the ability to opt out from these instructional materials. But it didn't say exactly what that notice looks like, when that notice needs to be provided, or how parents are to opt out of these specific instructional materials. So it really leaves a lot of gray area when it comes to implementing this holding in day-to-day school activity. So with that, it's important to understand this Supreme Court decision, the implications that it may have, and come up with a plan to best comply with this holding, understanding that the Supreme Court didn't give us a lot of guidance on that. Okay, so with that, I'm going to turn it over to Bob, who's going to talk about really the policy implications of this and how districts can kind of implement this ruling through their district policies.
Thank you very much, Alex, and thank you all again for joining us. Super important decision, right? We've seen some pretty significant changes in our legal landscape, particularly around religious rights in education. Going back to the Kennedy case that came out of Washington State with the coach praying at the 50-yard line, Fellowship of Christian Athletes that I'll reference here in a little bit as well, that just tend to be showing the same trend as what we saw in Mahmoud, which is this Supreme Court and the appellate courts at the federal level are clearly leaning in a direction that provides more religious rights and more protection for people's individual religious freedoms. So we know that this is going to impact policy on many levels. We know that it's probably going to go a little bit beyond that, right? As Alex said, this has got some pretty broad implications. The court here framed the decision in terms of a religious objection to instructional materials. It was not specific to these particular books or the content of these books, but rather the family's objection to that content on a religious basis, right? So if we extrapolate this a little bit and we think about something like the famous Scopes trial, right? The monkey trial back in 1925 about whether or not a teacher could teach evolution in public schools. Highly contentious, big national event, even though it was a Supreme Court case. It was really a defining kind of landmark moment in education, right? Evolution versus creationism. Since then, we've all been pretty much teaching evolution in the classroom. The objections in that case were largely based on religious beliefs and, at the time, current law. So when we look at the application of Mahmoud, you have to start wondering, like, if it's based on instructional materials and religious objections, are we now going to start seeing objections based on that kind of content? My religion says we don't believe in evolution. My religion says we don't believe in interracial marriage. My religion is anti some other religion. Is this going to open the door to a whole lot of different objections? We'll have to see. We have heard rumblings of that from certain districts where they've had some parent groups voice concerns or that this hasn't gone far enough. And so we may be seeing that get pushed. We've also heard some concerns that, much like in the fact pattern of what happened in Maryland, that there may be certain groups that kind of flood a school district with these requests for opt-outs. And in fact, we know of at least one organization that has created a plan or sort of a roadmap for how to do exactly that. Overwhelm school districts with objections to the content with the goal of getting the district to stop teaching that instructional material. Whether or not that happens, we have to wait and see. So far, we've seen more objections and more conversation around what are the practical implications? How do we go about implementing this in terms of notice and the form of an objection and that kind of thing, or the opt-out requests? But we haven't seen a whole lot of people actually requesting the actual opt-out of the instructional material. But the school year is young, so we'll see what happens. In terms of people flooding you with those requests, don't forget that you do have legal obligations under the FAIR Act, under state law, right? Mahmoud didn't say we don't teach this instructional material. It said you have the option to opt out of it, or the parents have that option. California law under the FAIR Act still requires you to include certain aspects of the contributions of different groups of Americans, as Mariella alluded to earlier. So remains to be seen how far this goes. No doubt there's going to be additional litigation on it, and that's going to shape and refine this ruling and how we move forward. So as we've already said many times, when this comes up, please don't hesitate to contact your legal counsel, whether it's us or someone else, but these really need to, a lot of thought and consideration needs to go into any of these opt-outs. So, and I will talk about the notice and the opt-out here in a minute, but first let's talk about the policies that are directly impacted. When this case first came out, a lot of people were looking at board policy 6144 on controversial issues. That got a lot of attention just because of really the title of it, right? The controversial issues policy is a little broader than just religion, right? It covers any kind of topic socially, politically that may be coming up in the classroom that's going to draw perhaps some heated conversations or issues, right? So one we've heard a lot about in the last year or so is conversations around the Israeli-Palestinian conflict. That clearly has some religious aspects to it, but really it was more of a historical thing, and how do you get into that? Controversial issues, the policy, already included language that says, when required by law, parents and guardians shall be notified prior to instruction that they can request in writing that their child be excused from that instruction and that their student may be offered an alternative activity. The key to that language is when required by law. So in effect, that policy already covers the Mahmoud situation because, as Alex said, this is a Supreme Court case. So it is now the law. So when required by law, you may need to allow the opt-out. So that being the case, edits were not made to the controversial issues policy. Instead, they focused on the ones that were that are listed here on the slide. The primary one being 6141.2, recognition of religious beliefs and customs. This policy permits teachers to objectively discuss the influences of religions using religious works and symbols to illustrate the relationship between the religion and culture, literature, and the arts, and those kind of things. But it does require that the district respects each student's individual right to freedom of religious practice. So you can't do anything that even resembles indoctrination or pushes a student to participate in a religion. It's more like a factual, how did this religion influence the culture or art of a particular community, maybe in your history class, right? The law is really clear. The staff cannot endorse, encourage, or solicit any religious or anti-religious expression or activities among students during class time. You can't coerce students in prayer or any other religious activities as part of your official duties. Now, where that gets a little blurred is that Kennedy case I mentioned earlier. What exactly are official duties and when exactly is that occurring? Because when a teacher is acting in their private capacity, they're actually not prohibited from encouraging students to participate in personal prayer. So we have some gray area there, right? Some things where the court has clearly indicated protection for religious activities of the individual, but when that individual is a teacher, there isn't a real clear boundary or even a real clear test anymore as to where exactly that line gets drawn. So again, if it comes up, please talk to legal counsel. Other thing that's in this policy talks about how school districts cannot prohibit religious activities of staff or students if they're going to allow non-religious activities to take place that are similar, right? So this is where that Fellowship of Christian Athletes case comes into play. That was actually a case in 2023 against San Jose Unified. In that case, the Fellowship of Christian Athletes, a student group, they had a requirement for any of the leadership of their club to sign a statement of faith that effectively discriminated against LGBTQ students. School district said, you're welcome to have your club. We're not going to fund it. It can't be getting student body funds because we think that's a form of discrimination against the LGBTQ students. The Ninth Circuit looked at this and said, well, it's based in their religious beliefs. And if you're going to allow other clubs to create rules around who's in the leadership, then you have to allow religious-based clubs to create rules as well. So again, the court clearly indicating we're leaning towards protection of religious values. So what do we do in this policy? This policy has a lot of new language in it that is specific to the Mahmoud case. And it basically says when required by law, districts have to notify the parents and guardians that they may, again via a written request, opt students out of instructional materials based on their religious beliefs. Again, it mentions that students and parents, or students whose parents opt them out, may be offered an alternative activity. It says may because it's going to depend a little bit on the facts and circumstances. Are we talking about a 10-minute reading of a book, or is this going to be a day-long activity, 2-day-long activity? And so that's going to kind of be dictated by what's going on in that particular classroom in that particular moment. The other thing that's really important that came out of the Mahmoud case and also is pretty solidly grounded in California law as well, no student can be subjected to any sort of disciplinary action or academic penalty or really any kind of sanction based on the grounds that they were opted out of this instruction. So if they choose to get out of it or the parents want them to get out of it, then you cannot hold that against them in any way, shape, or form. The other policies where this really came into play is 6142.1 and 6142.8. These are kind of similar. Both of these policies deal with the Healthy Youth Act that Mariella talked about. The Education Code requires students in grades 7 through 12 to receive comprehensive sex, health education, and HIV prevention education at least one time during junior high or middle school, and at least one more time during high school. But the law also says the schools must respect the rights of parents to supervise their students' education in these areas. And so it allows a parent to opt out of that. But there are limitations on that opt-out under California law. Under California law, textbooks that just include a description or illustration of human reproductive organs are not something you can opt out of. Instructional materials that include discussions of gender identity or expression or sexual orientation cannot be opted out of. That is no longer the case under Mahmoud. So state law, FAIR Act, Healthy Youth Act, you cannot opt out of those particular things. But if they happen to contradict a sincerely held religious belief under Mahmoud, now you can opt out of it. So we added language to that policy that makes it clear exactly what it is that is included in, needs to be included in the district's comprehensive sex, health, and HIV education program, and also that you have opt-out language. The reason we made it pretty explicit about what needed to be included is to help parents understand, and this goes to sort of the notice piece under Mahmoud, what is going to be taught, but it also helps you guys understand and make sure that you're not inadvertently removing any content from the curriculum in an effort to prevent opt-out requests or to address opt-out requests preemptively, because you still, under the FAIR Act and under California law, have to include certain aspects of this in your instructional materials. So the other thing that's covered in this under 6142.8, as Mariella mentioned, there are surveys. If you have a survey that contains age-appropriate questions about students' attitudes towards sexual practices, you have to allow families to opt out of that under California law. Same with health instruction. If it conflicts with moral beliefs, instruction in sex or health related to sexual assault awareness and prevention or HIV prevention, right? So any of those now are kind of subject to being opted out of. Mahmoud just kind of strengthens some of those existing principles and creates this mysterious notice and opt-out language. What does this really mean in terms of notice and opt-out? Unfortunately, as we've talked about, we don't really have great signposts along this journey. The court did not give us any hint as to what it means, because here in California, we don't have a lot of opt-out options. The only thing we can really turn to and look at as a model is what we've done for sexual health instruction. Again, the outline of that is found in the 6142.1 board policy and regulation. And what that one was based off of state law, right? And so basically the notice requirements here, and this goes to one of the questions we saw in the chat earlier, notice has to be sent out at the beginning of the school year or at the time of a student's enrollment. So typically the sex health opt-out language should be included in your annual notification to parents. It has to include that the educational materials being used are available for inspection. The parents and guardians have a right to opt their student out if they submit a request in writing, and that you also, parents and guardians, have a right to request a copy of the applicable ed code sections, which is, if you want, 51.930 to 51.939 if you're really interested in that. It also says that the notice has to clarify whether instruction will be given by district staff or by outside consultants or presenters, and if it is by someone outside of the district, you have to notify them who is presenting that and when are they presenting it. So in terms of the sexual health curriculum opt-out, that's what state law requires. Now, conversations that I have had and my colleagues have had with other attorneys, we're not so sure that a single upfront annual notice is going to be sufficient under Mahmoud. Again, the court didn't give us real guidance here, but given the strong protections, it's safe to assume that you should be a little bit cautious on this. So we're recommending that you maybe provide that annual notice, but you also provide a list of instructional materials that are going to be used in those classes. Maybe that's just included in your syllabus, and that you give a second notice, some sort of additional notice as you approach the date in which those instructional materials are going to be used. That puts more onus on the districts. It's going to put more onus on the staff. But I think if you're just simply saying you have a right to opt out of instructional materials that you object to religiously at the beginning of the year, you are likely to find parents who are objecting because I didn't realize this was being taught. You didn't tell me that curriculum was being taught. I didn't know it was that book that was going to be read to my children. And based on what we're seeing in the courts, they're probably going to have a pretty solid argument against you. So the more notice you can provide that they have the right to opt out and what the actual materials are is going to be helpful. Because remember, the court was saying specifically it's a very fact-intensive review, and the facts depend specifically what are the instructional materials and what is the particular religious belief and where's the intersection there. So it's fact specific on both sides of that. if the parents don't know what's being read, it's really hard to say that they have the facts to make that sort of informed decision, if you will. So what's an opt-out actually look like? Once again, the Supreme Court didn't really help us here. So we are recommending, and everything I've seen is recommending really that it be done in writing, much like the sexual health instructional opt-outs. There's quite a few reasons for that. Mostly it's going to give you a paper trail and document things and make it a lot easier for you in case this ever blows up into something different. Some districts we're seeing are creating forms, and we're happy to help you with that if that's what you're interested in, but creating some sort of general format so it's a consistent type of opt-out. But really what needs to be included in these opt-outs are the specific instructional content that the student wants to opt out of. Again, they're going to need to know what's being read to them, right? What is the content so they know what specific instructional content to opt out of? What is their specific religious belief or custom or practice that the content is going to interfere with? I saw a question in the chat earlier about what constitutes a sincerely held belief. The courts are pretty clear. What constitutes a sincerely held belief is what the person says they believe. You are not likely to prevail if you try and challenge whether or not somebody's sincerely held belief is in fact a sincere belief or actually religious, right? They're going to probably prevail on that. So whatever form of opt-out though needs to say, what's the content? What is your belief? And how does the content interfere with your belief? This one's a little squirrely because people might get a little feel like they shouldn't have to justify this. But we believe under Mahmoud, the case was pretty clear that it's fact specific, and without those facts, the district can't make those kind of determinations. Now, unfortunately, this puts a lot on you, puts a lot on the school district to have to make that decision. Except we can't really challenge successfully or reasonably what somebody considers a sincerely held belief. And I suspect we're also going to have a lot of problems challenging whether or not something is offensive to those beliefs. Because religion is such a subjective area, the courts usually have sort of an objective standard with a subjective belief component to it. Here, I think we're going to probably throw out that objective standard. We'll have to wait and see how it gets defined, but it's really going to be, this is my religion, and this was offensive to me. So if that's the case, and if it's plausible, right, we don't have a kid just saying, shoot, I didn't study for math today, that goes against my religion. Okay, that's not going to work, right? But if it is plausible that it's a sincerely held belief and that this is an offense to them, and they've requested that opt-out, you should probably strongly consider granting that opt-out. Again, speak with your lawyers, especially until we get this sort of down and find out where our boundaries are, but also make some considerations. When you opt that student out, what are you going to do with them? Do they get an alternative assignment? Where are you going to place them if they leave the room? Who's going to supervise this student? Do you have, you got to think through these kind of things. If you opt out one student, are they going to be targeted for bullying? Or is it going to somehow create discrimination against them? Or potentially a form of discrimination against students who aren't opting out? Unfortunately, not addressed by the courts. We'll have to kind of wait and see what happens there, but be mindful that those are the kind of things that could bubble up from this, right? As soon as we're creating a different classification based on religion or based on, in the facts of the case on gender, you're in danger of potential discrimination. So just be mindful of those. And again, we recommend that you work with your legal counsel when you encounter all these opt-outs. So with that, let's turn to questions.
So Bob, there's several questions in the chat. In other words, the district can't define what is substantial, correct?
Yes,
from.
that's correct,
Okay.
right? That goes to whether or not it's a substantial belief. And it's, again, it's a pretty subjective standard that the courts have applied over the years in different contexts. So I'm assuming that's going to apply here as well. The district could get themselves in trouble.
Okay, so policy 6241.2, fourth paragraph. Can you give an example of acting in their private capacity?
That's a fun one. I don't, Alex or Mariella, if you guys want to weigh in on this is the gray area that was created by the Kennedy case. In that case, the coach was at the 50-yard line with literally at one point it blew up into a media thing. And so there were at one point there's photos of hundreds of people on the 50-yard line praying with this football coach after a football game. And the court said it was private personal prayer. So we used to have a pretty bright line, right, under the lemon test of if you're in your instructional capacity, right, if you're in the classroom or the kids are in your presence, just don't engage in your religious activity, right? If you've got like a little religious thing on your desk, that's fine. But if you're pushing anything or doing anything religious in the presence of kids, you've probably crossed a line. The court in Kennedy was pretty clear that that's not the case. In that case, right, the coach's classroom is the field, and the coach was in his classroom surrounded by children and hundreds of people, and it was deemed private activity. So what's acting in their private capacity? Not in the classroom, right? In terms of teaching time, is it in passing periods? Probably in a gray area, but you're probably still going to get in trouble if you're a teacher doing that kind of stuff during passing periods. In your classroom after school, the last bell is rung, you're probably going to lean in favor of the teacher. During lunchtime, good question. I don't know. Alex, Mariella, thoughts on that one?
The only thing I have to add is whether or not the employee is free to attend to personal matters. I think the court kind of came back to that idea that if the employee is available to attend to a personal matter at that time, the court is likely to say that that time would be considered private capacity. But again, as Bob mentioned, there's a lot of gray area here. And the Kennedy case kind of really flipped our idea on its head with respect to our previous boundaries of when an employee was on personal time. So things have kind of changed a lot, and it is difficult sometimes to identify what that personal time is.
Yeah, I agree.
Okay, so next question in the chat. We received a parent form letter listing their religious beliefs and asking for a blanket opt-out for the year from any instruction in conflict with their beliefs from advocates for faith and freedom, requesting opt-out of any discussion regarding gender and even character education. Do you have recommendation regarding how to handle these preemptive blanket opt-outs?
That is interesting. Do you two want to weigh in on that? I have some thoughts, but I'm curious what you two have to say on that one.
Yeah, I have some thoughts on that too. So I think this is an example of when adopting a formal opt-out form may be helpful. Because if you have a formal form that requires people to identify the specific instructional material that they wish their students to opt out from, identify their religious belief and how that specific instructional material interferes with their religious belief, then you kind of remove this ability to have a blanket opt-out form because they have to identify specifically the instructional material that they take issue with. If you receive a blanket opt-out form like this, it's really requiring the district to identify what instructional material interferes or substantially interferes with their religious beliefs. And that's not really a position that the district can take because it's not the district's religious belief, it's the individual's belief. So I think if it were me, I think speaking with that parent to really identify what specific instructional material they are wishing to opt out from is the best course of action. Because really you can't, I would be very concerned about putting that onus on the district to identify what potentially interferes with an individual's religious belief without having them explain it explicitly what they have concerns with.
Yeah, I agree. The court language was that these opt-out requests will, quote, depend on specific religious beliefs and practices asserted, as well as the specific nature of the educational requirement or curricular feature at issue. So it is really one thing we can take from that language is it's a case by case individual basis. A blanket opt-out is probably too broad. I think I would respond very respectfully to those parents and say, we honor your request and this is your religious, viewpoint. We want to honor that. But we do, and you can even cite to this language, right? We can help you craft a response if you want. But citing to this, saying that it has to be, specific religious practices because you don't want to stand in the place of assuming anything about their religion, right? So if you're deferential in your response to them and say, of course, we want to honor this, we want to be deferential to your religion and not make guesses to what may or may not be offensive. So we ask that you give us more specifics on the specific, the actual curriculum you want to opt out of. That way you're putting it back to them, still honoring them and hopefully not offending, but religion's always, right? This is what we don't talk about at Thanksgiving, right? Don't talk about politics and religion with your family. So I think Thanksgiving got canceled a few years ago. Maybe I'm wrong.
Okay, another question. What about supplemental materials, picture books, etc.? Not something formally adopted, but commonly used for read alouds, etc.
Great question. Library materials, supplemental materials. So supplemental instructional materials are a little bit more gray. Library materials clearly outside of the scope of this. The case is specific to instructional materials and things that students didn't have the ability to opt out of. I think where we'll see challenges potentially are those classroom libraries, right? Are we going to start to see people objecting to some of the books that are in those classroom libraries? Currently, the state of the law is that that's not required reading, and because students have the ability to choose to read or not read or engage with that material, the courts haven't really gone there, right? So that's still kind of protected material under the First Amendment. So supplemental and library materials, as of now, not affected by this case.
Okay, great.
Hold on, there's a follow-up
There's
to that.
follow-up. Yeah.
Yeah. If a teacher reads a picture book out loud to a whole class, do they need to notify the parents ahead of time? I would say yes on that one because the students would be required to be sitting there with the teacher as the teacher is reading that book aloud.
Yeah, absolutely. I mean, those are the facts of the case, right?
Facts of the
That's
case.
exactly what happened in Mahmoud.
Okay, given the breadth of held religious beliefs and thus invariable conflicts across all academic subjects, coupled with the intersection of conflicting responsibilities dictated by state and federal decisions, how should we be vetting content and or providing guidance to teachers outside of policy?
Great question. Vetting content, you have to adhere to the state curriculum standards, right? We just saw last school year quite a lot of controversial stuff happening with adoption of instructional materials, right? The state was very, very clear in its position along the lines with the FAIR Act. If you are not if you are selecting materials that are discriminatory, which could include materials that explicitly do not include the contributions of, for example, LGBTQ plus individuals because of their status as an LGBTQ plus individual, that's a form of discrimination subject to a uniform complaint. And those complaints can be filed directly with the state and not even have to go through your district. That being said, again, this case doesn't say you can't teach those materials. It says you have to allow an opt-out. So as of now, follow the state curriculum requirements just as you always have, and then allow this notification and opt-out piece. I suspect, like Mariella said, we're going to see more conflict there. We're going to see that come to a head at some point. We're going to see somebody challenge the validity of California law. I don't see them as conflict. I see them as creating, unfortunately, a lot of extra work for school districts, but there's no, in my opinion, direct legal conflict there.
Okay, this will probably have to be our final question. We're at the top of the hour right now. Very interesting topic. Is there a way for an opt-out when the parents do not want to use religious reasons? Is this discrimination if the district does not allow the opt-out to occur?
Great question. Currently, it's religious reasons only. That's what the case was very, very specific that if it's, and Alex always sets a language that I never get right, but hostile to the religion or undermines their religious beliefs, then they have the ability to opt out.
Yeah, I will note though, the California Healthy Youth Act is not based on religion. So for the Mahmoud case, the opt-out needs to be based on religion.
Right. The other, yeah, your sexual health and the surveys and all that kind of stuff, that's already in state law. And so that's, I mean, it's not explicitly based on religion, but it is based
Yeah.
pretty much on people's religious and moral beliefs. So,
And is this discrimination if the district does not allow the opt-out to occur? So because this holding comes down from a Supreme Court decision and the holding is very much based on religious practices, I would say that there's not a good case there for discrimination if you do not allow an opt-out for non-religious reasons. Because the law at this point is clear that the opt-out needs to be based on religion for under the Mahmoud case. But you know, as Bob and Mariella have both mentioned, this case is ripe for subsequent cases to come down, so things can change.
Okay. Did we want to address a few other questions?
sure.
or
I mean,
do we-
I'm happy to stay on if you guys
You're happy
are.
to stay on?
We
Yes.
can keep talking
Okay, great.
about it.
All right. Does CSBA have a sample form exhibit that could be used?
We do not currently have a sample form that's attached to our sample policies. We have been asked to create forms for some districts. I know some of the other law firms have too, and we're happy to do that. Part of the reason we don't have a sample form is that districts are approaching a little bit differently in each district, right? Some may want a single form, some may want it broken out, some, you know, so we're happy to work with you guys on that. If you'd like us to help you with the form. CDE does have opt-out forms, I believe, right, Mariella, for the sex ed courses.
They do,
So
and I can
that's
put
a-
that on the chat there. If anybody wants to take a look, I can put the link there.
Yeah.
So we don't have sample notices for each policy, correct?
Correct.
Correct. Okay. Okay, I think that's the last question. So if you have further questions, please feel free to reach out to us. We're happy to answer any questions for our clients. We really appreciate you all being here. And get a chance, please fill out the happiness survey. And we will see you next month. All right. Thank you so much, everyone, for attending. We appreciate it.
Thank you.
Thank you.